We used to see judiciary as somewhere where we can run for justice and you hide. At least you hide from there. These days, Madam Chief Registrar, the public is seeing the judiciary being in connivance with the oppressors. You can, even if you go to court now,
Honorable,
in a court.
Honorable of our political statements, but I want them to, if they are to address the issues, let's be mindful of the language.
Yes. You, Chair. Of course, most of the time there is a controversy or a dispute. We used to say, even if you take me to sales, at the end of that day, I'll appear before the judge. These days we look at the justices, the judicial officers, receiving people who have been tortured, bleeding, limping. And unless a person writes them, please, I was tortured, the judicial officers close their eyes without necessarily putting on those which we used to call the judicial eyes, the judicial glasses. What happened? When you go to court right now, is it a directive that no person should be given a bail unless he first go and test the prison? No more granting bail instantly. Are the judicial officers weak? That even a simple matter cannot be heard on bail instantly?
Okay.
It is so painful, Chair. That's why the other time I opted to tell you that I should come last. So I beg that, much as we are aware that there is that another entity which is supposed to come, but this is our big, and this is the mega one.
That's why I gave you an opportunity first, so that you raise the issues from the alternative government.
Thank you, Chair. Of plea bargain. Chair maybe did not highlight it further, but Chief Registrar, are seeing plea bargain versus a would-be fair trial. People are yearning to attain their liberty than to be in detention, and they opt to go to plea back to enter that process of plea bargain. But the issue which is surfacing now, me and you and many other people here, with this system which was initiated, once a person's plea is entered, it automatically goes on through the system. And all embassies across access this system. I don't know how, but they access it. You apply, for example, to go to get a visa. A person is denied a visa by virtue of the fact of that conviction which was entered onto his name. Why? The magistrate did not have many, for example, in the courts where I operate, I cannot simply say that in Buganda Road Court, in Mukono Court, in Wachiso Court. What happens, there are some officers which I think they are we call them state who are holding on state briefs. They only tell you plead guilty. At the end of the day, you are going to be ordered to sweep around to do community work, without necessarily explaining to him the implication. And the gentleman said, I did not commit this thing, but for the sake of this, let me accept. This happened especially upon the people who were arrested during the elections. Sarah, you are representing.
No, you are protected. People. Please, Honorable Abdallah, you are protected. Pay attention to the chair.
Thank you, Chair.
Address the chief.
Especially the people who were arrested during elections. Many were arrested. At that time, the prisons were full. Of course, even the prison people were complaining. Yes, we welcome what was happening about the plea bargain, but people right now are suffering because of the conviction, the conviction note which was put against their name. How can we address this to get a fair and speedy trial against these small small offenses, not necessarily entering plea bargain. Finally, in the meantime, temporarily, the chairman, finally, there is this called JELOS, Justice, Law and Order sector, where several entities, police, judiciary, prisons, come on board to discuss various issues. I understand that you have discussed severally about people who have been in detention for more than 8 years, and they have never been tried. By virtue of my office where I sit in, I interact with police, I interact with prisons, and they only throw it to you that you are the ones who are not hearing these cases, yet you are also throwing it to police and DPP about the scarcity of the state attorneys and the police's failure to investigate on time. And in such circumstances, you also deny bail. You are making it harder for these citizens to get liberty, and at the same time, or be tried. You have not tried them. You are not giving them bail, so they are in detention for more than 8 years. Finally, about the case which is in court. I'm sorry to mention about this, but this is not sub judice. You have issued guidance to the public how to access certain case which is ongoing. It is extremely hard to access court because people can, yet justice must be in open court. Everyone should be following. But you have not put avenues, for example, to put us either to create a Zoom link or to create screens in the compound of court or in other courts for the public to follow. This has put the judiciary in my own way in a disrepute that you are hiding something. You are trying to convict a person while you are hiding them from following. Can you please, I'm advising, put screens, create Zoom links for the public to follow what is happening in court.
Thank you very much.
Thank you.
Thank you very much. Now, honorable members, I had to give the Shadow Minister of Justice and Constitutional Affairs more time because it has a constituency he represents in this committee. Now, let's have from the other members, but we have another entity coming in at 12:30 sharp, and yet we will need to accord them more time to respond to some of the queries we have raised. So, Salongo, honorable. Look at a close reading of Article 126. And I want to invite the Honorable George Musisi to just read us the first part of Article 126. Is the Honorable George Musisi still with us? Yes. Yes, Article 126 is where my major interest is because that's what brings out the judiciary.
It has been overtaken by events. I'm now in charge. Article 126, exercise of judicial power. Clause 1, established under this Constitution in the name of the people and in conformity with the law and with the values, norms, and aspirations of the people.
Continue.
Clause 2, in adjudicating cases of both a civil and criminal nature, the courts shall, subject to the law, apply the following principles. A. Justice shall be done to all, irrespective of their social or economic status. B. Justice shall not be delayed. C. Adequate compensation.
I think we can stop. I wanted to stop at B. And it is derived from the people who have the power. One out there would worry, are we still conforming to the provisions of Article 126? And that's the concern that we are picking from the people we represent. There are also other concerns that have come up, especially in the dispensation of justice. Are we still adhering to the principles of bail? So I want to invite you in your presentation to address some of these issues that you are privy to, and others that shall come along as the members respond to your presentation. Madam Under Secretary, I want to invite you now as the leader of the team. I don't know who you gave which responsibility to speak to us in relation to the communication that we made to you. Thank you.
Thank you very much, Chair. First of all, I would like to congratulate you for making it to this parliament, and also to congratulate members here for making it to this committee. We also thank you for your indulgence. You had invited us earlier, but you listened to us when we indicated that we had planned activities out of the city and we had failed to see how to. We have distributed a presentation arising out of your letter. We thought that we could prepare this to kickstart this discussion, and whatever may not be here, it's not that it's a deliberate effort to keep it away, but we felt that this is what we could prepare in the circumstances, and we are ready to respond to any issues that arise. And where we are unable to give instant responses, where we require documentation, we are ready, more than ready to do that, Chairperson.
Just an interjection. Does everyone have a copy of this? Clerk, make sure he gets a copy. Very quickly. Please carry on.
Chairperson, I also still want to continue thanking this committee. It has been very instrumental in highlighting. Of course, when I talk about this committee, I look at it that this is a continuation from the previous parliament. It has always been instrumental in really fighting for us in terms of getting funding and other resources. Of course, at times we don't get everything that we need, but we appreciate what you're able to get, not only about funding, but also the laws. Towards the end of the last committee, of the last term, we saw the enactment of the Magistrates Act, the Magistrates Courts Act, which is going to be really, we think is going to be a game changer. It addressed a few issues and so many other laws that were enacted. In this particular parliament, we are looking at so many amendments to the laws, and we shall be coming forth to look at them, whether what we are proposing will improve administration of justice. So we look forward to those interactions as we go along. So, Chair, I've alluded to what we have already distributed as our presentation to kickstart this engagement. And with your permission, I will be asking members to present on some of these matters so that it is not a monotony or a monopoly of presentation. Chair, the first slide on page 2 talks about our mandate. You have already asked a member to read this, and I think that was very clear. I don't have to belabor the point any further. But allow me highlight our vision. Our vision is justice for all. And our mission is to efficiently and effectively administer justice. We have a strategic goal. This goal appears in our strategic plan. We have a strategic plan for this development period, which ends 2030. And our goal for this period is a responsive and efficient judiciary that guarantees equitable access to justice for all. Chair, I know some members may know the structure of the courts, but we thought we can still allude to it, that we still have one Supreme Court of Uganda headed by the Chief Justice, and it has an establishment of 11 justices, and we are happy to report that it is currently fully constituted. The Court of Appeal is the next level, and it is headed by the Deputy Chief Justice, which also sits as the Constitutional Court. The court has an establishment of 35 justices, but we currently have 19 justices. We had wanted this structure to be 55, but in the previous parliament when we presented this, because we were looking to having a structure that will be able to man the 8 circuits that have been gazetted. So in the wisdom of parliament, they first gave us the 35, but I really believe that we believe that when we have these circuits, we may have to come back if the circuits have to be meaningfully manned by the required number of justices. And also, as we will later on see, the backlog at that level is high, and there is only so much one human being can do in a day. So when we do the ratios, we'll still have to come back to have this number of justices increased. At the High Court, which is headed by the principal judge, We have an establishment of 150 judges, but currently we have only 88 on the bench. We have 7 divisions of the High Court, that is the Civil Division, Criminal Division, Commercial Division, Land Division, Family, Anti-Corruption, and International Crimes. And we have 29 circuits operational out of the 38 gazetted, and the list of the High Court circuits is there. Chair, allow me not to go through them, but they are recorded there. And then we have a number of magistrates' courts organized under magisterial areas, and our magisterial areas now are based on districts. So each district is able to have a chief magistrate, but currently we have 157. The chief magistrates' courts are 157, and only 92 are operational. Of course, on our side, we would wish for them to be operating, but we have challenges which are all surrounding the limited funding, because these courts will need accommodation, whether owned by the government or rented. We have to recruit, we have to tool the officers with furniture, ICT equipment, and the like. So with that background, Chair, allow me to invite the Chief Registrar to take us through the performance of courts as at the end of the financial year 25-26.
Thank you very much, Honorable Chair and members. I'll look into the performance of the courts for financial year 2025-2026 as reflected on page 3. There is a table shows at the end of the financial year 2025-2026, we had a total caseload of 477,507. Out of this, 269,668 were completed in that financial year, and then the pending that were carried forward to this financial year were 207,839 cases. Next is the breakdown of the caseload per court level. We have the Supreme Court again showing pending of 1,136 at the close of the financial year. Court of Appeal closed with 14,682. The High Court closed with 90,332, and the Chief Magistrates Courts closed with 75,315 cases. The Magistrates Courts closed with 26,374 cases. Again, the next page, page 4, gives us the summary of the performance by case type for the financial year 2025-2026. If you look at those figures, we again break them down to the different case categories. We have civil at the end of this financial year. The performance was that we closed up again with 65,409, criminal 72,068 cases, land with 40,631, commercial 7,942, and it follows as you can read in the table below. So I invite members to look into that table.
Thank you, Your Worship. Let me just highlight about our budget performance, and she'll continue to talk about case management. Chairperson and members, last financial year, we had a total budget of 435. Chair, as a background, we needed about 600 billion, but this was appropriated for us. And this led obviously to some things not being attended to, especially case management, alternative dispute resolution, rollout of ECMIS, and infrastructure. We have a very big challenge on infrastructure. And of course, also as background, we had been promised that by the financial year 2024, 2025, our budget would be at 800 billion for us to be able to efficiently and effectively administer justice. So this is where we stand. This year it has increased a little bit to 479 chairperson and members, and that is the breakdown. We have 109 billion on wage. We have 313 on operations, non-wage. Development, we have a meager 56 billion. I call it meager because you will see, you all know, you're in those constituencies, you know the state of our infrastructure. It is appalling, it saddens us, but that is really the state we are in. And then domestic areas, this year we have 120 million. So that is how our financing looks like, chairperson and members, and we shall be speaking to the challenges arising out of them later as we look at the challenges as we close this presentation. Chair, once again, allow me to ask the Chief Registrar to continue with case management.
Thank you. Honorable Chair and members, we have a planned output for this financial year. And when we look at that table, it gives what we have projected to be here. The Supreme Court has planned to complete 122 cases. Court of Appeal, 1,742. High Court divisions, 28,132. High Court circuits, 36,539 cases. Chief Magistrates Courts, 144,728. And the Magistrates Courts are 80,259. Now, these projections are made basing on the previous year's performance, looking at the way the cases are being registered. So this is how we came up with these targets. We also plan to, in this financial year, we are going to have an exercise of transfer of cases from the High Court to the lower court after the amendment to the Magistrates Court Act, which happened in the last Parliament. The jurisdiction of the Chief Magistrates has now been enhanced to 200 million from 50, and for the magistrates to 100 million shillings from 20. So we are going to see a number of cases that were previously in the High Court cascading down to the lower courts. So we have made some projections here. We have that the Chief Magistrates Court, a total of about 14,975 cases will be transferred from the High Court to the Chief Magistrates Courts, and of these, 4,859 cases are backlogged. So there is a lot of work that is going to be done to be able to clear this backlog because it's being transferred down. This will reduce case backlog at High Court by that figure. The Magistrates Court, we are estimating that about 19,506 cases will be transferred from the High Court to the Magistrates Courts, and of these, 6,181 cases are backlogged. This is as per the records that we have been able to get from the cases that we are sorting out. The CJ, the Chief Justice, the Honorable the Chief Justice has signed the practice direction, and it is due to be gazetted for implementation. Move to Chair and Honorable members. We have the rollout and use of ADR, Alternative Dispute Resolution, that is currently being undertaken by Judiciary. In this, we have mediation. In this room, we have the Registrar Mediation, and she's overseeing the activities of this registry. So the Judiciary is rolling out court annexed mediation under the Judicature Court Annexed Mediation Rules of 2026 to reduce on case backlog. Not only reduce case backlog, but lower the cost of accessing justice and make justice more accessible to the people. In the financial year 2025-2026, 10,686 cases were registered for mediation, and 3,503 cases were brought forward from the former year of 2024-2025. A total of 7,118 cases were disposed of while 6,702 remained pending, resulting in an overall mediation success rate of 45%. I wish to comment here that this is something that is being embraced slowly and gradually by even our legal fraternity. So we are hoping that in this financial year, we shall have an improvement in performance as people get to know more, get more aware of the benefits of mediation. So below is a figure below shows the performance of the mediation program. Again, it's tabulated. I'll leave that to the members to just have a look at. We also have the plea bargain program. Plea bargain is a process that involves the prisoner accepting to admit his guilt in exchange for a fair sentence. The advantages of this system is that it saves state resources and limited judicial time that would otherwise be spent on hearing witnesses and proving cases. Again, the narrative continues. In the financial year 2025-2026, a total of 10,066 plea bargain cases were concluded under the plea bargain program, comprising 9,100 cases sentenced through quarterly court returns. And again, the breakdown is as provided. And figure below shows the performance for the plea bargain program for the financial year 2025-2026. We had in quarter one, we had 1,031 cases. Quarter two, 1,006 306 cases. Quarter three, 3,149 cases handled, and in quarter four, 3,614 cases handled. Overall, JTI also, the Judicial Training Institute, they held a special session and they were able to handle 966 cases. Overall, the total plea bargains in that we handled in the last financial year were 10,066 cases. Chair and members, we also have the small claims procedure. The small claims procedure is a reform initiative of the judiciary intended to enhance access to justice for litigants with commercial disputes whose value does not exceed 10 million. So this is basically to cater for our smaller businesses. The small claim is operational in 223 courts across the country. In financial year 2025-2026, a total of 24,429 cases were registered, and out of these 27,181 cases were resolved, and 3,633 cases remained pending. The clearance rate was 111.27%, while the disposal rate was 88.21%. The total recovered value, the money that this program was able to put back into the economy, was 20.43 billion shillings. Again, the table below shows the overall performance of and includes by a demand notice. So again, the table below gives us the performance of the small claims. Again, members, I invite you to also look at the tables. Those tables just basically explain the performance of the small claims in the financial year 2025-2026. We have automation of courts and management of cases. We have had the rollout of ICMIS, Electronic Court Case Management Information System. This is a comprehensive IT-based system that automates the entire life cycle of a case, starting from e-filing of a case to its e-archiving. Again, to date, ICMIS has been rolled out in 56 stations out of the 275 operational courts all over the country, and this constitutes 21% of coverage so far. In the financial year 2025-2026, ICMIS was rolled out to 23 court stations, namely, these are the High Court. What we do is that we capture the High Court and the courts under it, in the circuit. So we've been able to roll out in High Courts of Mukono, Mbarara, Chiboga, and the subordinate courts, and Gulu. So, and including Chief Magistrates Courts and the Magistrates Courts, because they all feed into the High Court. So we have to make sure that we do the entire circuit. So far we have rolled out in those circuits, and we are looking forward to extending it further to other High Court circuits. Thank you very much. So if again we look at the table below, the impact of onboarding courts on ICMIS, the rollout of ICMIS to courts has seen cases filed on ICMIS from services. So for the first phase, we are piloting this system with the chief magistrates and then the systems administrators. We want to evaluate that performance with this first group and then eventually roll it to others. Honorable Chair and members, this is a tool that ensures that a person is assessed not only by the supervisor, but even by subordinates, by the advocates. You should be able to assess the performance of a judicial officer using this tool. Thank you very much.
Thank you, Your Worship. Chair, allow me now invite the Commissioner for Policy and Planning to take us through the construction of court buildings.
Thank you, Accounting Officer. Thank you, Honorable Chair. I'm continuing from page 10, construction of court buildings. Chair and members, Judiciary is constructing a number of courts across the country. And to start with, we are constructing the regional courts of appeal. And specifically, we've started with Gulu and Mbarara. And the status is indicated. For Gulu, we are at 15%, and in Mbarara, we are at 13%. Constructing High Court, and specifically, we are constructing a High Court in Soroti and Tororo, and we are at different levels, as indicated in the narrative, Chair. In the interest of time, I will not read all the words indicated. We are also constructing Kivale Justice Center. Now, this Justice Center basically covers not only a court, but we are also constructing a building for ODPP, police within the same location. So that is the idea of Justice Center. So we are at 7%, but we are progressing. We are also constructing Chief Magistrates Courts in different courts, Amolotar, Bubulo, Katine, Rakai, Namutumba, Lebtong, and Liantonde. So those are the Chief Magistrates Courts we are constructing, and they are at different stages as indicated in the narrative below. Chair and members, on page 11, we've indicated the artistic impression of how these regional courts of appeal will look like. So where we are constructing, this is how we shall be having those structures once completed. The other courts we are constructing are the Magistrates Courts, and specifically we are constructing one in Abim, Madiokolo, Riarusanje, Ruguburi, and Adwari. And the details of where we've reached in the construction have been indicated in the narrative below that subheading. Then, Chair, the other thing we have embarked on is constructing the institutional houses. This is to help us to accommodate our judicial officers, especially in hard-to-reach areas, and also areas where it is not easy to get accommodation, decent accommodation. So it is an initiative that the judiciary has taken on to ensure that we construct institutional houses. Again, we are doing it in Buheju, Karenga, and Moyo, and we've indicated the levels we've reached, and these are almost at completion level. Chair, again, we've also continued renovating our court buildings. A number of them are in sorry state, so we've continued renovating them, and for last financial year and also continuing this financial year. We are renovating in Mbarara building, which is housing the High Court Circuit. We're also renovating the building in Jinja, which is housing the High Court Circuit. It is a Chief Magistrate's building, but housing the High Court. We are renovating it, and Fort Portal. And we've indicated the percentages where we are with these renovations. The other court buildings we're also renovating, the Chief Magistrate's Courts, Yumbe, Moyo, Kaberemaido, and Bushenyi. And I've indicated the percentages where we've reached. And then we're also renovating Magistrates Courts of Muru and Bukedia. We've also indicated the percentage where we've reached. Chair and members, again, judiciary, like you mentioned, we've done quite a lot. We've also been able to procure a number of transport equipment. And specifically, Chair, we're able to procure a boat to help us be able to reach the islands. So we've indicated that picture for you to be able to see. This is real, the boat is there. It's not that we're just highlighting it. And then over the period, to date, Chair, we've been able to procure 439 vehicles and 340 motorcycles in total for the institution. Thank you.
Chair, let me wrap up this presentation with the challenges that we are encountering in execution of our mandate. The first one we had already indicated is the inadequate budget. We had submitted, as I earlier indicated, a budget of 633, but we received 479. Of course, Chair, we appreciate that there are many national competing priorities, so we get, but of course, it doesn't remove the challenges that arise from not getting what we think. Even when we are actually submitting, it's not that we submit everything. We take into cognizance of the fact that there are other priorities, but still when we get what we get, we appreciate it and hope that the other challenge, so of course what arises from this inadequate budgeting is that critical funding areas rather remain unfunded. Case backlog reduction. We would have sessions for this if we had sufficient funding, facilitation for locus visits, implementing all the ADR initiatives like mediation. State briefs are highly underfunded. Construction and renovation of court buildings. Oftentimes the contractors have to demobilize because of insufficient funding or releases. For instance, on development budget alone last year, we performed at 74%. So even the little we had that had been appropriated to us, we ended up not getting 26% of it. And then, of course, digitization. The electronic court case management, we should be having it in much more courts than we are reporting, but we are still grappling with rolling out. Video conferencing, which is very good for online hearing of these cases. Court transcription, which also improves the efficiency of the judicial officers, is, I don't think we are even at 5% yet. So that's what underfunding leads to. And if you look at page 14, the case backlog right by the end of the financial year 25-26 stood at 207,000. And case backlog, we defined it as cases that have stayed in the system for more than 2 years, and some certainly are longer than that. The breakdown of the case backlog is indicated there at the various court levels, and on the table on page 14 below also indicates the pending cases and then the case backlog. On page 15, we indicate the value of the pending cases, therefore the impact they have on the economy. At the commercial court alone, we are looking at 2.14 trillion cases, the value of cases. At the civil court of the civil division of the High Court, it is 10.6 trillion. The land cases are valued at 2.9 trillion, family cases at 9.79 trillion. So delays in resolving these matters directly affects investment and productivity, as you may be aware, Chair and members. And in the table below, we have tabulated the value of the cases that comes to 25 trillion. That is the money tied in the courts for cases that are pending. The table on page 16 also continues to break down further visually for members to look at when they have time. Still, the issue of funding underfunding leads to staffing gaps. We still face a shortage of gaps in our staffing, both for judicial officers and the support staff. And there is a table there that indicates how our structure is filled. On the upper bench, it's only 59%. On the lower bench, 58% filled. And the administrative staff, only 34%. And on page 17, we indicate the judicial officer workload ratio analysis. And this, of course, is what translates into the case backlog. The second slide on page 17 also highlights the inadequacies amongst the justice institutions. Chair and members, as you are aware, we are implementing government business by programs. The judiciary heads the administration of justice programs, so we are alive to all these challenges within the program, but also in the course of our duty, it comes out very glaring when you find that there are no prosecutors at various courts to prosecute cases, and also the slow rate of investigation of matters. So that also affects our output. Then infrastructure gaps, that one cannot really be overstated. Members here, your members in your communities, you know the state of our premises. It's not because we don't see, we see and we are desirous of improving them, but we can only do to the extent of the funding. And of course, we would love also to have so many buildings like you heard. There are so many high courts operating in chief magistrates' courts. That alone is a problem. Then, of course, there are those without buildings at all. So that infrastructure gap remains not only in the buildings, but also on the ICT, which is now really very necessary in promoting efficiency. So number 6 highlights the slow automation of courts. Everyone would be desirous for ECMIS to go everywhere, but it's a heavy investment, especially in terms of the hardware, because we already have the software. It's there to roll out. But the hardware, it's expensive to buy this equipment, the computers, for everyone to use, because there are several users within the courts. So, and we set up also kiosks for the public. So it's a heavy investment, and we are unable to roll out to the desired pace. And finally, the low wages of administrative staff. We are able to at least have the judicial officers enhanced, and we thank government for that. But the administrative staff are very poorly paid, and this affects morale. We continue to push and pray that this is also afforded by government. And Chair, these are the measures we are taking to strengthen efficiency. What that is required to strengthen efficiency. First of all, again, it is to enhance the budget so that we are able to address these challenges that we have highlighted. And through that, we should be able to, if we can recruit more judicial officers and administrative staff to handle the work, strengthen ADR, because we have, ADR makes not only is it faster to resolve matters, but it also leads to amicable conclusion of cases, and then we have harmony within our societies. So if we strengthened ADR, we would see more cases resolved, like we've seen in the statistics, Chair and members. Then operationalizing the remaining high courts is one of the measures that would improve efficiency and effectiveness. operationalizing the courts of appeal. Like we indicated, as you saw, there is a lot of backlog at that level, so having these courts of appeal in the regions would also lead to efficiency. Expanding the court infrastructure, that is more court buildings and more ICT infrastructure. Acceleration of automation. Chair will have a robust IT strategy and policy, and if we did this, if we had this implemented, it would lead to efficiency in the courts. The other measure is to strengthen the inspectorate of courts to deal with maladministration. And Chair, we plan to have at least 2 regional offices established next financial year. This is in our strategic plan, and we hope that next financial year, 26-27, no, 27-28, we shall start with 2. Thank you very much, Chair and members, for listening to us.
Thank you, Madam Under Secretary. I have members who came in after we had done the introductions. Let's have them introduce themselves, starting from the extreme end.
Thank you, Chair. Good morning. I am Campania Abduswaibu, representing the people of Waikiki constituency, Budaka district.
Thank you.
That is the Eastern Uganda.
Thank you.
Thank you, Chair and honorable members. My name is Vavulanda Welkataike Matilda, woman member of parliament.
But the reason why we said let's first start with the 19 is that we looked at a team of 3 justices to constitute a panel of the Court of Appeal. And we said if we could have one for Kampala, one for Central Region, one for Northern, one for Eastern, one for Western, that would make 15. But also let's have 3 justices for a mobile panel or on reserve in case one of these is not around, he can chip in. And then we also, that would make it 18. But the reason why we made it 19 is that the Deputy Chief Justice should continue giving administrative role over the court. And we knew that once all these 5 are operational, then you would come back and ask for us to increase the number so that you are able to cover up the other areas. So that was the reasoning behind the approval of 19 as opposed to 35 at the time. You also note that when we approved 135 judges of the High Court, we still have a total of around 80, is it 83, 81? 88 who are already recruited. So that was the explanation. Now, on the issue of the budget, we have always had an input in the budget, especially for unfunded priorities as this committee. But as you know, the budget for the judiciary under Article 128(6) is a statutory budget. So most of the discussions before coming to this committee are done with the head of the executive, and there are always prior agreements before. But we must acknowledge that there has been a substantive increment from 2021 going forward, a very, very substantive increment. And we trust that that increment shall go on until it is all uhuru. So that is on the issue of the budget. Now, Madam Under Secretary and your team, there are issues that we expected you to hint on that are making headlines and making some of my members very uncomfortable. For example, the level of tolerance by the judiciary. It is assumed, and rightly so, that by the time someone rises to the level of a High Court judge, a justice of the Court of Appeal, or a justice of the Supreme Court, or a Chief Justice, must have an average level of tolerance and acceptance of scrutiny from the public without offense. Some of these matters, because of the sub judice rule, we are inclined not to comment directly. But if I had the privilege, I would name cases like the Mabirizi case. These are matters where we would expect a level of tolerance from the bench without having a lot of hullabaloo. So we expected you to tell us what is guiding this. Then secondly, the standoff between, I will call it a standoff in the Uganda Law Society. Partly, the judiciary is responsible. And we are, as a member of the Uganda Law Society, I feel concerned. We are your number one clients. You ought to understand the politics and not be privy to the small politics that is pertaining in the society. That way we are having challenges. The Judicial Service Commission is supposed to have members from the Uganda Law Society. They are not there because we have a court order, which in my opinion, anyway, should have been discussed and resolved amicably by other means without going so legalistic and formal. Also, we note a lot of improvement in the number of cases, especially in regard to the use of technology. But from the members of the bar here, sometimes when you file a matter on IKIMIS, you also have to accompany it with a phone call to say, I have filed. Is it on the system? And they will say, we are checking, but we can't see it. How are we working on resolving those issues? I have personally been a victim in the Mbale court where we filed a matter and it could not be reflected on the system. And we were penalized for that. So what is the problem? There has also been growing concerns of plea bargain. The judiciary owes a duty to the suspects to explain to them the implications of the pleas they are taking. Some of them, after saying yes, and then when they leave, they say, oh, but I didn't know this consequence. Now I am a victim. Is there a way you can liaise with the office of the DPP to have this matter clearly understood by the suspects before they enter into plea bargain? I need to thank you clearly for the improvements, especially in the Liantonde court and the Madi Okolo. I visited those two areas. When I reached Liantonde, they told us that is the court. We said, but where is it? They said, no, that one. You could not actually believe that it was a court premise. But I was amazed with the young man we found there. His worship, the magistrate, had a heap of files and was dispensing his duty, regardless of the circumstances under which he was operating. To get a place of convenience, he needed to move about 100 meters. Then he comes back, and it was very ridiculous. So I want to thank you for those interventions you've made. The issue of backlog, I am actually looking at the statistics, and they are still very high. Budgetary increments, is it an issue now of allowances? Is it an issue of manpower? What exactly is now holding us? Because from 300 billion, I think this year we are getting around 600, 470, in 2026, 27, 479. There has been a steady progress, but the issue of backlog is still a very big challenge. Now, we have raised the case of other sector players, like the state attorneys. In Kamuli, where I come from, until recently, we had one state attorney with 3 magistrates. So all of the courts, all the other court premises had to come to a standstill, waiting for the state attorney to leave one court premise and go to another. Until recently, we had a second one. But remember, Kamuli is handling both Kamuli district and Buyende. So these are 4 magistrates, but still up to now we have. So we have raised this matter with all the powers that be, and we trust that there shall be an action taken. And lastly, before my members chip in, the department, or whatever it is, of Inspectorate of Courts, probably, how many staff do we have there? Because you find there are areas where brokers have even opened up offices near the court premises to speak to the litigants so that they are able to go and speak to the magistrates about. Also, some court officials, especially the clerks, even request, have you spoken to so and so? Because they know so and so is the one who speaks is still lacking. We say all this because we have a duty to invite my members to weigh in and raise those issues. And I will start with the Minister of Justice and Constitutional Affairs, Shadow, because you're a consumer principal.
Before this issue of ECMIS, Chief Registrar, leave alone following it with
by the way, you should start with congratulating her.
I'm on that I feel happy for not only for you, for many other people who are seated here, whom I have not openly declared that I know them, but I know them and they know me. Miss, leave alone following it with a phone call. Actually, it has jeopardized the workings of court. You go at court, ECMIS is not on. The judicial officer has to tell you, now what should I do? You look at, is it the problem? Is the problem with the judiciary itself or with the service provider? Have you tried to harmonize this issue with the service provider that court system is not jeopardized? Suspects are brought, the system is off. They end up getting taking them back. That is issue number one. Issue number two, over or the accounting officer to explain to us this issue of bail. The article which was read at the commencement, when the minister was here, we put it to him, where does this, that the judicial power is derived from the people? People can look at you. For us, when we are still laymen, we used to see judiciary as somewhere where we can run for justice and you hide. At least you hide from there. These days, Madam Chief Registrar, the public is seeing the judiciary being in connivance with the oppressors. You can, even if you go to court now,
Honorable,
any court.
Honorable of our political statements, but I want them to, if they are to address the issues, let's be mindful of the language.
Yes. You chair, get justice. Of course, most of the time there is a controversy or a dispute. We used to say, even if you take me to sales, at the end of the day, I'll appear before the judge. These days we look at the justices, the judicial officers, receiving people who have been tortured, bleeding, limping. And unless a person writes them, please, I was tortured, the judicial officers close their eyes without necessarily putting on those which we used to call the judicial eyes, the judicial glasses. What happened? When you go to court right now, is it a directive that no person should be given a bail unless he first go and test the prison? No more granting bail instantly. Are the judicial officers weak? That even a simple matter cannot be heard on bail instantly?
Okay.
It is so painful, Chair. That's why the other time I opted to tell you that I should come last. So I beg that, much as we are aware that there is that another entity which is supposed to come, But this is our big, and this is the mega one. Which
That's why I gave you an opportunity first, so that you raise the issues from the alternative government.
Thank you, Chair. Of plea bargain. Chair maybe did not highlight it further, but Chief Registrar, are seeing plea bargain versus a would-be fair trial. People are yearning to attain their liberty than to be in detention, and they opt to go to plea back to enter that process of plea bargain. But the issue which is surfacing now, me and you and many other people here, with this system which was initiated, once a person's plea is entered, it automatically goes on through the system. And all embassies across access this system. I don't know how, but they access it. You apply, for example, to get a visa. A person is denied a visa by virtue of the fact of that conviction which was entered onto his name. Why? The magistrate did not have many, for example, in the courts where I operate, I cannot simply say that in Buganda Road Court, in Mukono Court, in Wachiso Court. What happens, there are some officers which I think they are we call them state who are holding on state briefs. They only tell you plead guilty. At the end of the day, you are going to be ordered to sweep around to do community work, without necessarily explaining to him the implication. And the gentleman said, I did not commit this thing, but for the sake of this, let me accept. This happened especially upon the people who were arrested during the elections. Sarah, you are representing...
No, you are protected. Please, Honorable Dala, you are protected. Pay attention to the chair.
Thank you, Chair.
Address the chief.
Especially the people who were arrested during elections. Many were arrested. At that time, the prisons were full. Of course, even the prison people were complaining. Yes, we welcome what was happening about the plea bargain, but people right now are suffering because of the conviction, the conviction note which was put against their name. How can we address this to get a fair and speedy trial against these small offenses, not necessarily entering plea bargain? Finally, in the meantime, temporarily, the chairman, finally, there is this called JELOS, Justice, Law and Order sector, where several entities, police, judiciary, prisons, come on board to discuss various issues. I understand that you have discussed severally about people who have been in detention for more than 8 years, and they have never been tried. By virtue of my office where I sit in, I interact with police, I interact with prisons, and they only throw it to you that you are the ones who are not hearing these cases, yet you are also throwing it to police and DPP about the scarcity of the state attorneys and the police's failure to investigate on time. And in such circumstances, you also deny bail. You are making it harder for these citizens to get liberty, and at the same time, or be tried. You have not tried them. You are not giving them bail, so they are in detention for more than 8 years. Finally, about the case which is in court. I'm sorry to mention about this, but this is not sub judice. You have issued guidance to the public how to access certain case which is ongoing. It is extremely hard to access court because people can, yet justice must be in open court. Everyone should be following. But you have not put avenues, for example, to put us either to create a Zoom link or to create screens in the compound of court or in other courts for the public to follow. This has put the judiciary in my own way in a disrepute that you are hiding something. You are trying to convict a person while you are hiding them from following. Can you please, I'm advising, put screens, create Zoom links for the public to follow what is happening in court?
Thank you very much.
Thank you.
Thank you very much. Now, honorable members, I had to give the Shadow Minister of Justice and Constitutional Affairs more time because he has a constituency he represents in this committee. Now, let's have from the other members, but we have another entity coming in at 12:30 sharp, and yet we will need to accord them more time to respond to some of the queries we have raised. So, Salongo, honorable.
Registrar, I am one of the people who wish you the very best in that. I thank you for your insight, but there are some two issues which I thought they should also be addressed by this panel. The first one is derived from Article 126(2)(b), that justice shall not be delayed. In reference to the case backlog, we have so many cases which have taken more than 10, 15 or so years, especially in land. And in your presentation, you highlighted that this case backlog, especially in land, has even scared away investors. So what's your take on this? Because justice delayed is justice denied. What's the essence of someone getting a judgment after so many years when even the status quo has changed? What's the essence? Maybe
just before you, does the system that we use, either ICMIS or the others, show how old the case is and the last action taken when it was filed? Are we able to see that there is this 20-year-old case, this 15-year-old case, to give it priority in cause listing? Okay.
Thank you, Chair. Is in reference to Article 126(2)(e), substantive justice being administered without undue regard to technicalities. We have rightly observed that ECMIS is one of the biggest technicalities that the court system has created. So many judicial officers either delegate their powers or relegate their powers, actually, simply quoting the ECMIS system. So many of us, including yourselves, we are born before computer, and you are enrolling us on a computer system where we don't have the knowledge, you have not taught us, you've never carried out any substantive sensitization of your judicial officers. So many of them, especially in those up-country courts, claim that they don't know the system, so they rely on either clerks or someone you've designated to do that aspect. The same applies to advocates, the likes of us and whoever. And then how about the litigants who are unrepresented? The unrepresented litigants, how do you expect them to get on board the ECMIS system without sensitization?
Salong, are you suggesting we go back analog?
Chairman, that is evidence from the bench.
Oh, you're giving feedback.
I am giving feedback because I represent.
Because I will not accept to go analog again.
No. I am urging the judiciary to that aspect of telling us, sensitizing the litigants, sensitizing the advocates, and even
the judiciary for this presentation. I failed to declare my interest because I'm now out of judiciary officially. But I want to tell you, Mr. Chair, don't worry, Mr. Chair. But on a lighter note, Mr. Chair, I want to bring to the notice of honorable members that judiciary has had enormous migration to the better. Like Honorable Salongo is talking about, there has been a migration from CAS into HMEs. This is to simplify the registration of cases, especially in urban areas where lawyers like him operate. The other analog part is for village courts, where there is no maybe network issues and all that. But we must appreciate that judiciary is moving to the better. I want to handle on a few things on fair hearing, speed hearing, and the Honorable Shadow Minister of Justice has talked about. And I would like to quickly that there is also another improvement on quick disposal of cases, that judiciary has been put under pressure to dispose of registered cases 60 days limit. And I think that's a plus for them that require an applause. On political cases, I also want to, because I was part of this system, I want to tell you that when a political case comes before you, like most judicial officers, there is enormous pressure on both sides, especially when it comes to application of bail. You're under pressure from those who are pushing it and those who want to get out. What is the safest net for a judicial officer? To avoid serious issues that would come to you as a person. Sometimes it is safer for you to remand a suspect or an accused person for a small period of time to reduce the pressure from both sides. And it should not be prolonged. Justice and Constitutional Affairs. Justice and Constitutional Affairs. I need to be. Thank you.
Is overruled. Honorable Abdallah,
thank you. Thank you, Chair. We all kept quiet.
These people gave you time.
Yes.
And listened to you. I want you to listen to them. Please proceed.
Honorable Abdallah, Chair, I want to, first, maybe I would be the Moses and the Joseph in the Bible in this part here. But above that, we need to appreciate that judiciary is doing its best to serve the people of Uganda in terms of justice delivery. I have only three issues. One, that was a preamble. One, Mr. Chair, is yes, Mr. Chair. Now, the people I represent, because that is where I want to. I come from Kapchorwa Sabei sub-region, Mr. Chair. Mr. Chair, there are several meetings taking place.
Please proceed.
Thank you, Mr. Chair. Thank you, Mr. Chair. I come from Sabei sub-region with a total population of now over 500,000 people. We have Chief Magistrates Court, one, seated at Kapchorwa, and there is a Magistrates Court in Bukwa. In Kwen District, there is no single operating Magistrates Court, and that's where my interest is. I need to inform our judicial officers who are here that we need a Magistrates Court in Kwen District, because jurisdictional issues now come in. Where do they go? Do they take their cases to Bukwa? Do they take their cases to Kapchorwa? That's one. Two, on that basis, we rely on high courts in Mbale. And we have three issues that involve around there. Language barrier. We are the only Kalenjin-speaking people in Uganda. And so when our people come to Mbale, they face enormous language complication, especially where there are no court interpreters. We only have one office attendant in Mbale. We don't have a translator in Mbale. And so we have our people having injustices around there.
Important to the
Two,
people,
the distance.
We need the high court.
Yes, the distance from Kapchorwa, Sabei sub-region to Mbale is a problem. Cost implication, what and all this. So we need a high court circuit in Sabei, stationed at Kapchorwa.
Thank you so much. Your last one.
Now, Mr. Chair, I sit on the budget committee, and I saw $0.something billion that was initially planned by judiciary to 479.3 something. Of course, that's an inadequate amount of money. And of course, because I sit on this committee and also on the budget, I want us to have a negotiation to increase that amount to at least 580 billion. That would sort out many things that judiciary, especially on infrastructure. Now that I'm pushing for a high court circuit in Kapchorwa, that amount will cater for the part of the infrastructure. Lastly, on amendment. Lastly, Mr. Chair, which is very important, just one.
The people of Sorot should be represented.
Yeah, thank you very much, Chair. First of all, I want to support my in Kapchorwa because politically, Sebei is a region, and all regions apart from Sebei have high court statutes, so they deserve.
But Peter, that has been deliberated on very well by Honorable Chitio.
Yeah, so I just want to support him.
Thank you very much.
Yes.
Honorable Masho.
No, I am still submitting.
Honorable Masho. Okay, Peter, finish your point.
So, whereas I have conflict of interest, but I want to talk on something which is important. Initially, when they started the JELOS, and I was part of the team which started it, it was supposed to ease coordination and then sharing of information. Initially, judiciary was not there. They had a changing system, which I was also part of. But when they came to JELOS, apparently they have divorced from JELOS again, and now the judiciary is on their own. I wonder why the judiciary decided to go alone, because now the coordination, the sharing of information is going to be affected. So why did the judiciary again divorce? Then secondly, on salary, this guy is up. The lady talked about salary enhancement. We had the DPP here and other institutions. Is the judiciary implementing their salary enhancement, or they are facing challenges? You wanted to know.
On that one, I can authoritatively tell you, the chief to the fullest. Is that the position? Yes, and that's they are the ones who have the reason, not me. Honorable Marshall.
Thank you very much. Thank the team from the judiciary. We are very satisfied. They're doing great. Secondly, on the issue of Pakwach, we have the rangers always arrest fishermen on the waters of Jonam. That's not the problem. The problem is they take them to Masindi. I already asked the Minister of Justice here. We have a magistrate's court in Pakwach, which is just meters from where they arrest these people. But they take them up to Masindi. And right now we have over 59 people in the prisons of Masindi, unfollowed, plea not taken, just because of distance. Masindi is over 140 kilometers from Pakwach. I already told the minister, I wish I could have a reply. Secondly, Pakwach doesn't have a court hall. Pakwach rents a shop as a magistrate's court, and the shop is next to a disco, next to a saloon, and next to a boda repair station. Very ugly. I wanted to know how these courts are being built. At one time I heard that they were supposed to build a court in Pakwach. It never materialized. Now that I am in the chair in Pakwach, I wanted us to see how we can work on that. Finally, on the issue of the transfers, we have friends who are magistrates and in your service. They seem to believe, I also join them in believing so, that the transfers in the judiciary are opaque, that there are some specific people who work in the cities and those who work in the jungles. Could we come clean on the policy of transfers? Thank you very much.
Thank you very much.
Thank you, Chair. I wanted also the judiciary to talk about the 330K, that is 330,000 that is given to magistrates that covers housing, transport, lunch. Remember, most of them operate in rural areas. I think this is a way of demoralizing them. Then also, they have no working. It is too little. They get it for a month. That is too little. They have no vehicles, and most of them operate. They should also have priorities. Then also, Chair, they have no working tools. If you come to my court in Semujju, you can get embarrassed. So they have no working tools. Then lastly, there are scenarios that judiciary can handle that is embarrassing. Suspects appear for court, they wait for the magistrate, later on they are informed, you know the magistrate is not coming, so you take them back. Imagine such a scenario. May I request they should communicate in time so that they don't waste resources. Thank you very much.
Thank you very much. Honorable Pio.
Thank you very much, Chair, and the judiciary. Quickly, and you'll forgive me, Chair, because I'm going to ask some very uncomfortable questions because they really must be asked. Recently, judiciary, there were transfers different from the normal transfers my colleagues are talking about. Transfers associated with the granting of bail to opposition leaders and certain activists. Persons perceived to be critical of government. And they were accompanying, notes or submissions to that effect that these judicial officers were later transferred because of the services that they rendered that may not have made others uncomfortable.
Is that factual?
That's what my constituents are talking about. I'm a representative of my people.
But we have to be very cautious with any factual statements from members.
What I'm asking is that, what I'm asking the judiciary, Honorable Chair, is regarding the safety of our judicial officers.
Okay, that's important.
I would like clarification on that. If they are comfortably doing their work without due interference, that is one. Two, on the issue of case backlogs, is there a mechanism for the judiciary whether adjournments, and undermining judicial independence?
Thank you very much.
And quickly, finally, because I'm really quick, Chair, 1 minute. On the issue of barring the press, especially, from attending hearings, judiciary. Especially yesterday, we had returns from the courts of law. A presiding officer issued instructions that the hearing associated with the Muwanga Kivumbi case would be done behind closed doors. I would like clarification on that, because we believe that justice dies in darkness. Just to substantiate on what my shadow minister said, would it be okay for the judiciary to guide that the public, especially for matters that are of great public interest, like that one, the political interest cases, be allowed to be accessed by the public, as my shadow minister stated? Would really appreciate that.
Thank you so much. Honorable Secretary.
I have two questions. One, from your presentation, you listed the ongoing constructions and renovations all over the country. I would like to know from you whether you have all the required resources to see these projects to completion. Then, two, what measures have you put in place to prevent corruption and the unethical conduct among the judicial officers?
Thank you so much. Oh, you see?
And finally, it's also about case backlog, because when you look at page 15,
25 trillion.
25 trillion. I would like to know what you are doing to avert this trend.
Okay. Thank you so much. Honorable Eliab.
This issue of specialized courts. One is arrested in Bwindi, impenetrable forest, in Chigezi. They bring this person to Uganda Road. What is the judiciary doing to operationalize specialized courts in Uganda? Even the cases of migration I have asked here before, Chair, we have issues of refugees and migration. What is the judiciary doing in terms of putting a specialized court for these foreigners that have immigration-related issues? Secondly, Chair, on page 7, the accounting officer has talked about small claims, and she says that there is operational in 223 courts. But I don't know where she gets the figure, because from my understanding, when you do the mathematics, the Chief Magistrate operational courts are 92, and the Magistrate Court is 145. And when you add those two, it comes 237. Maybe I'm having a different book, but if not, I want them to be on record so that they can brief us.
Thank you.
And the third one, Chair, is that, yes. What is the judiciary agenda on career development and even promotion of some people? We have seen some people who work as magistrates. They begin at that level, they even retire as a chief magistrate or even as a magistrate. What is the judiciary really doing on that one? Thank you, Chair.
Thank you so much, Honorable Campagna.
Small claims. There is a tendency where money lenders have abused small claims. Process servers, they will go, come back and swear that they have served. And then after, they will come back to court, get a court order to go and arrest this person that he was served, he never responded, and this person is brought before court, taken direct to prison. And this has been taking place. I don't know whether judiciary is aware, and what steps are you going to take? Because it is being abused, mostly money lenders. The person will just see police coming for him, you were served, you never responded. Secondly, on interpreters, to be specific, it is something I witnessed in my district, where an interpreter is not from that given district. Okay, he does not speak the language Rugwele, to be specific. He learned Rugwele and is struggling to interpret. And look at the injustice where someone has said a different word and the interpreter is struggling to say something different. And the person will end up not getting justice because the magistrate is picking different thing from the accused person, specifically what he has said.
How bad. Thank you so much for raising that. Let's go to Honorable Ruhindi.
Appreciate this interaction. I have already declared my conflict of interest. I worked with most of you for many years. What I want to talk about is the issue of cooperation. We have come a long way. In the olden days, we all remember the days of Montesquieu in France, the French Revolution, the calibration of the principle of separation of powers. At that point in time, its application was very strict, I can tell you. Separation of powers. But in modern times, we are migrating from that aggressive competition to cooperation. Why cooperate? Article 1 of our Constitution talks about power belonging to the people. Article 126 talks about the judiciary, that the judiciary should be a people-centered judiciary. So we account to the people. With us as members of parliament, we go back to the people every 5 years to assess us. With you, we call you here. I remember in my olden days as a member of parliament, there is one person we called to answer to certain queries, and he refused. Says he was independent. But time came when we had to summon him to answer to queries of monies which we had appropriated. Had no choice but to come. And you can imagine what happened to him. So, cooperation is very crucial. We don't even need to summon you. You can also invite us. You can also call us. You say, you have an issue, how do we deal with it? You see, separation of powers is to the extent of a person or an individual or an organization is given latitude to make a decision without undue influence. But it is not a shield against accountability. We confuse the two. At the end of the day, we account to the people. So to me, what I wanted to emphasize, Mr. Chairman, is that this interaction should be enhanced in many ways. We reach out to the judiciary, even at the highest level. There should be a platform where, for instance, the President and the Chief Justice and the Speaker interact in the interests of delivering service to the people. But that rigid, I could hear even some members of Parliament saying, I can never meet the President. Why should you say that? Then how will you serve the people? So I thought I would clarify this and encourage us to continue in dialogue for the sake of delivering service to our people. Thank you so much, Mr. Chairman.
Thank the Chief Justice on his invitation under the leadership of Justice Owiny-Dollo to discuss issues that are pertaining in the judiciary. We look forward to the same invitation. But if it doesn't come, we'll request for one. It's within our liberty, and we interface with him and the rest of the team. Because some of these issues we raise, you may be guarded to respond to them. Lastly, let's hear from the Deputy Chair.
Yes. Let me thank the judiciary for many progress. Chair, allow me also to ask them, when it came to small claim procedure, there is actually a total value recovered of about 20, is it trillion? Something, billion, something, over. It is undisputed that mediation is actually helping us recover capital or money that has been locked up. Yesterday, I attended at the Supreme Court roundtable. We talked about the mediation fortnight, which is also coming up. Let me declare my conflict of interest. I'm a mediator at the Commercial Court. Chair, the question I have for these people is that what was budgeted for mediation? How much was released? Can this money be ring-fenced for mediation? Because it cuts across all the different courts, not just the small claims court. Mediation saves costs, mediation is faster, mediation is easy to access. How can we put more? Let's put our money where our mouth is, if we say it is what is working. And I think when you talk about ADR, I would also like to hear about transitional justice. How are you handling that? I know time is limited, so also when we had another stakeholder here, Chair, you remember, I think it was Judicial Service Commission. When we sat down in the 10-fold growth strategy by NDP 4, we actually, as political supervisors, added corruption as one of the other strategies for growth. They informed us of around 4 judges almost being investigated. Corruption in the judiciary brings disrepute to the administration of justice, and many times when that happens, people run away from court. And what is the alternative? Lawlessness. So how can we help you, whether it's in terms of budget? I know you talked of regional court inspection center. I don't know whether that is meant to help with that, but really how can we help? Because with corruption, with a bad name, with that disrepute, I think we can lose the fight, irrespective of all the good things that we have had that you're doing. So I think, Chair, and as I conclude, there's no ECMIS in Patongo Court, where I come from. There is no state attorney in Patongo, according to DPP. how is all this affecting your justice to my people of Agago? Thank you.
Thank you so much. I don't know where you are.
Thank you, Chair. There is an issue of construction of the court premise dispute between Kawari District local government and the judiciary. So I wanted to know how far it has gone so that as politicians we can follow it and resolve it since we have a new leadership. Thank you very much.
Thank you very much. Honorable Deke, you had an issue.
Honorable Chair, my apologies for coming to understand from the judiciary on the issue of criminal sessions, criminal files. My name is Adeke Anebaju, Soroti District Woman Representative. So I've seen, something I've noted is that most times criminal issues are only heard during criminal sessions. And that has, in one way or the other, contributed to the overcrowding in prisons because many criminal matters remain pending and are not disposed of for so many years. And so the accused persons remain on remand, very long remand periods. Now, what I'd like to understand from the judiciary is why has it become a practice that criminal matters have to be put on hold until criminal sessions? Can't these matters be disposed of in the daily conduct of court sittings and all? It only happens when a criminal session happens, and the budget, Honorable Chair, for a criminal session, because a criminal session has to be allocated its own budget, and the budget is oftentimes not available. So you find that most high courts, where there is a circuit, they have like 2 criminal sessions in a financial year, which is really inadequate to deal with the backlog. So what I really want to understand that issue about, criminal files. Why is it only mention,
Thank you.
and only for criminal sessions?
Thank you so
and
much.
How can we support you to maybe to have these matters handled, not just to wait for criminal sessions so that they are dealt with? Thank you.
Honorable, strictly give you 1 minute.
Yes, thank you, Chair. Madam Chief Registrar, you see, I happen to be working hand in hand. Even right now, much as I'm a member of Parliament, I'm always in court. There is this issue which I think you should also try to give us some explanation or give it some deep thought. There are some magistrates who get transferred. They are not, this is not the omnibus transfers which you normally do. But upon handling some cases which feel that they go deep to offend some people.
But the Honorable Pio raised that issue. The Honorable Pio raised that issue.
Sorry,
Yeah.
I thought that she had not.
That was raised.
But
by the
so far
Honorable
I had two instances. I think she brought them up.
Yeah, the Honorable Pio raised that issue.
In the eyes of the public, it doesn't go down well. And
Don't worry, she articulated that issue. She articulated that issue very well. Now, Madam, of the many salient issues that are coming from the public, these are representatives of the people. They are concerned about issues like they have raised the bail, backlog, absence of judicial officers, non-operationalization of some courts in some areas, and these are not light issues. I am scheduling you next week to come and respond to these issues as they have raised them, so that we have ample time to respond. So I just want you to give your parting remarks. We shall schedule you next week. You come and respond to these issues as they have been raised. I am sure you have noted all of them down. Thank you very much.
We do appreciate you for giving us this opportunity to appear. I think we shall be able to talk more when we return on the next occasion. Thank you.
Thank you for this time. We thank you for all the issues you have raised. Some of them were counsel, and we take them very seriously. The comments to improve, we also take them very seriously. And the clarifications that you require, we are going to put them in writing and send them and come back and clarify where there may be need for clarification. Thank you very much for this engagement.
Thank you very much for coming. We look forward to seeing you next week. Honorable Chwanuka Abdallah. Thank you so much. Thank you so much. Thank you. Andrew, please usher in the next team very quickly. We want to finish this discussion. Thank you, sir.
N'ogwengulu okulaba ng'emisango gino gitambula ffe tugezaako okugukola abalamuzi tubawadde etteeka twaliyisa naye likendeeza n'emisango okuva mu high court naye abantu basigadde mu makomera emisango gy'ebyenfuna gikyali mingi egy'ebyettaka gikyali mingi ndowooza abalamuzi nabo bafuba okuba nga beefubako okulaba ng'emisango gikendeera baweeyo obudde kituufu batugamba nti emisango egimu naddala egya criminal abatalamuza emyaka 8 munda nti ba state attorney nabo batono naye ffe tulowooza nti wadde state attorney batono at least twandibadde tugiraba nga gikendeera oba ejja civil nga gikendeera kubanga state attorney wabeera nga tebaliiwo abalamuzi bandibadde nga babeera mu misango gy'ebyettaka oba ejja civil I mean ba state attorneys bandibadde waba nga tebaliiwo abalamuzi bandibadde bakola ku gy'ettaka naye n'egy'ettaka gikyali mingi ate nga nabo tufubye okulaba nga ennamba yeeyongera ensonga y'obuli bw'enguzi ne system gye bayita eya ekimis eyaleetebwa eganya emisango mingi nnyo okutambula otuuka mu kooti ng'ogenze kukoza musango nti system yavuddeko kiki ekiviirako system okuba nga tetambula twetaaga service provider mulala oba kubanga engeri gye baziza kooti ne baziza ku ekimis kati tosobola kugenda n'otandika kukoza nga system teriiko ne system is always on and off
ku bimu ebiyinza okuyamba judiciary okukendeeza ku misango egyo ekisooka nga yo judiciary erina okukitwala nga priority okukendeeza backlog ezo kubanga ku issue ezimu ze boogedde bali understaffed osanga wamu nga bamagistrates tebaliyo abyonoonyi oyo ndowooza judiciary ebintu ebimu birina okubisoosowaza nerekako ku bimu kubanga issue ya backlog waliwo ensonga waki waliwo backlog tusanze nti bali understaffed awamu courts ezimu nosanga nga zirina omulamuzi omu yadduka eno yadduka eri ba state attorney tebamala nolaba nga really balina challenge enene nze ndowooza bandibadde bongera okurecruitinga then n'ekirala nze kyendabye nti n'amakomera gajjudde makomera olusi gajjudde ebintu ebitaliimu omwana yabbyeko ko bamuzizaayo then ne judiciary kenyini erina okwetereeza basuspects babaleeta mu kooti ne balinda omulamuzi letero ne babagamba omulamuzi tagenda kujja ne babakwata ne babazaayo. That is wastage of resources. Nze ndowooza nabo nga bo balina okwekyeka okulaba nti bakola emirimu nga balina okugikola.
Kati nga bwe tulabye ebimu ku bizibu bye tukyasinze okuba nabyo y'ensonga ya backlog oba emisango kubanga gyetumye mingi nnyo mu makooti naye nga tegisalibwa. Mu by'essente tulaze reporting eraga nti obutabalika trillioni 25 bwe buli mu misango gye tuyita egya civil nga balinze okulaba nti bagidisposing off abantu basobole okufuna ssente zaabwe bagende bakole. So eyo kinyigiriza nnyo ebyenfuna naye mu byonna okusinza ku bwe tutambudde kiraga nti waliwo obunafu ku saidi y'abalamuzi. Kyova olaba tubakubiriza nnyo ekitongole kye tuyita Inspectorate of Courts kibeere nga kiri active nga kisobola okukola emirimu gyakyo bulungi nga kigenda ne bayalambula courts ezo ne balaba baani abataliiyo baani abaliyo mu makooti n'okulaba nga batuuka mu budde obutuufu nga bagenda mu makooti mu budde obutuufu. So bye twagala okugezaako okunyweza ebyo naye naffe nga paaliyamenti obuvunaanyizibwa bwaffe omanyi wabaddewo enjogera eya independence of the judiciary. Independence of the judiciary eyogera ku ngeri gye basalamu emisango. Siga nti olwokuba muli independent temuyinza agambibwako nga muzereti mu makooti abantu batuusa abalina okuwozesebwa naye temuliiyo basuspects baze emirundi 12 tebafuna bwenkanya. So ngaffe parliament naffe tulina okwongeramu nnyo amaanyi mu kuwuliriza ebiva mu makooti gano okuba tulina ba representatives mu nsi yonna. Member of Parliament alina okutuwa information evudde mu kooti ye tutegere ki ekitatambudde bulungi tusobole okukyanga nga kyova olaba tubagambye nti tugenda kuba nga tuyita abantu bano emirundi n'emirundi bwe tuba tuwuliddewo ensonga yonna kuba babadde tebakyakola buvunaanyizibwa bwabwe. Budget babongedde twali ku bilioni 3 kati tuli mu 4 tugenda mu 5. So enesa abandi badde batandika okukola emirimu gyabwe bulungi nga bwe kirina okukolebwa. Tujja kusigala nga tukirondoola. Then intervention ey'okubiri nti gyetumye mu kooti enkulu naye okusiza ku program bwe twayisa etteeka liri ery'okwongera abalamuzi bano abawansi ba chief magistrate ku ssente tebave ku $5,000,000 badde ku $2,000,000 tulowooza nti files ezimu bwe zinaavaayo eri mu high court ne ziddaano magistrates court wajja kubeerawo okuziwa obudde obumala basobole okulondoola emisango egyo nga bwe kyetaagisa. Lindiridde nnyo olunaku lwe tugenda obawa saabiiti ejja nga batuwa response oba okuddamu okulambikiddwa obulungi tusobole okutegeera lwaki ennaku zino beyiro eringa tekyali right. Kituufu wadde nga right ebadde discretion ya mulamuzi naye luli waliwo ebintu bye twasizirangako okulaba nti ono mubbi wa nkoko ke bamulese mu kkooti olw'okwewala okujjuza amakomera katumute ku beyiro bw'anaabazzemu okuzza omusango luli nga tutunula iziye first time offender bwe mulundi gwe ogusooka okuzza omusango ebyo byonna bibadde tebikyagobererwa bulungi ennaku zino so kyetugezaako okwetegereza naye nammwe ku saidi yammwe saagala nnyo mukitunulire nnyo ku nsonga ya misango gino egy'ebyobufuzi gyokka kubanga kooti ngazi gino emisango mubeeramu omusango gumu 2 3 naye tulina ebiri eri mu kyalo nti olw'okubona ayagala okunegotiatinga enguzi bail fee nti omusajja bamutute mu kkomera bamutute Kirinnya mwanguwe mangu mwogere naye bamukomyawo ku Lwakusatu okuwulira bail application. So ebyo tugezaako okugamba nti ffe nga abalina obuvunaanyizibwa bw'okulondoola amakooti gano tulina okwongeramu amaanyi inspectorate of courts erina okukola n'abalamuzi tulina okulaba nga tubateekako akazito basobole okukola obuvunaanyizibwa bwabwe mu bulambulukufu.
Not my practice normally. Welcome our guests. I see familiar faces, our worship.
Introduction, sir.
Yeah. I'm introducing myself.
By the Under Secretary, who is also holding court for the Permanent Secretary. Honorable Seka has just come in. Oh. We are glad to have you. We invited you here. I thank you for keeping time. I have realized you are not only class monitors, but you're also the start of the parliament. And being one of the entities that whose vote we scrutinize, we wanted to have an interface with you, give you a few of the salient issues happening from the people we represent, but also hear from you what is happening in the judiciary. What are the new programs that you have for this new term of government, or support you achieve your mandate without some of those challenges? So the purpose of course, there are a few concerns which we cannot overlook.